Okay, so now we're going to talk about Rule 8036 and 8037. This deals with documents that are regularly conducted business activity. 8037 deals with the absence of such documents. There's a lot of key terms to define here that mean a little bit more legally than they would in our day-to-day lives, but let's just read through the rules and explain. A record of an act, event, condition, opinion, or diagnosis, if the record was made at or near the time by or from information transmitted by someone with knowledge, the record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. C, making the record was a regular practice of that activity. D, all of these conditions are shown by testimony of the custodian or another qualified witness, or by certification that complies with Rule 911 or 12 of the statute permitting certification. And E, neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Break this all down. Really complicated exception, one that people get wrong a lot, but one that can be really powerful. So regularly conducted activity, the word regularly here, and this is 8036C in particular, making the record as a regular practice of that activity. The word regular is not doing it justice. It almost means automatic. It happens without fail. There's nothing you can do to stop it. There is this stimulus, this happens. Or there is a board meeting, there are minutes. And the presence of minutes can be entered into evidence to prove that minutes were kept at the meeting. Or receipts is a big one, regularly conducted business. Every time a sale happens, a transaction happens, a receipt has to be kept. Receipts are the exact type of thing that can be entered in under records of regularly conducted business. And those are the types of things that are regular. Namely, they were not generated by particular requests. They were not generated in response to trial. They were generated automatically as part of what the business normally does outside of the incident they are being investigated for or their evidence needs to be supplied for. Receipts is the biggest one. I can't say it again. But people mess up the regularly all the time. So you can really hammer on people if they're trying to say something's a regularly conducted business activity by hammering on whether it was truly regularly done. The next thing is that the custodian requirement. If it's someone who's trying to enter in receipts, you need the barkeep at the time or at least the bar's owner to see a specific bar tab. That's the custodian of the document. That's rule 8036D. All these conditions are shown by the testimony of the custodian. Namely, or in the case of the minutes, then by the secretary who took the minutes down, or a court reporter, whatever it happened to be. So the custodian requirement is there as well. It's not like anyone who has knowledge of that document can testify to it, because the specific method by which it was produced and kept in that instance is very important to know and needs to be cross-examined on before it can be entered into evidence. So it needs the custodian to be there. E is a general trustworthiness exception to it. Namely, the statement needed to be trustworthy on its face there needs to be no indication that it wasn't trustworthy. And when it says of a business is defined as not the police. So it doesn't have to be for profit, but people try to shoehorn the activities of a police department or the fire department as activities of a business, and those are not businesses. Things that they write, one, are prepared for trial, so they aren't regular. Like a police performs an investigation or a report in response to a specific event. You could imagine a situation where no events happen and no reports are filed. So there's an impetus. There's not an automatic thing that happens. So regardless, it's not regular. But secondly, police departments, there's case law in the real world, and it will not fly in AMTA either. Trust me, we've tried. I've heard people try. They will not fly as businesses. So in capitulating this, records of regularly conducted business, if they are truly regular, if they are done by a business, and if they are being entered in through the testimony of a custodian with no evidence that they have been tampered with or should be otherwise untrustworthy, can be entered into evidence. That's 8036. 8037 just says if there is a regularly conducted business activity that did not occur in a specific instance, then the absence of the regularly conducted business activity can be used as evidence for, one, the fact that it wasn't actually done, or B, that something was tampered with or something happened that was different in this case. So that you can read 8037 A, B, and C there for that same reason. So that's 8036 and 7. Yep.